Hello, hello, everybody. Welcome to Constitution Day at TMCC. Thanks for everybody for coming. And I want to thank all of you who are joining us on Zoom for this event that we hold every year on September 17th. And our purpose is to try to engage in a discussion about the U.S. Constitution. As you may know, 238 years ago today, 42 men exited Philadelphia, a small room in Philadelphia, with a finished constitution. 39 of them signed it, 3 refused. So from the very beginning, it has been not a finished document, but a document that is continually discussed and must continually grow or not grow, depending on your thoughts, to fit our current circumstances. So today we are very pleased to welcome a distinguished speaker for our event today. And I'd like to introduce you to Zelalem Begale. Zelalem Begale is a first-generation Nevadan like me, who, like me as well, we share a lot, Zelalem, like me, also has Thurgood Marshall as one of his heroes. He built his career as a prosecutor in the Washoe County District Attorney's Office, and he was recognized as Attorney of the Year while he was there. He also served as the Deputy General Counsel for the Nevada System of Higher Education, and TMCC is part of that system, of course. He now works on environmental policy for Berkshire Hathaway Energy, and in addition, he teaches at the University of Nevada, Reno. He mentors students through the We the People program. I know some of you in the audience have been part of the We the People program, and he also serves on the Northern Nevada Judicial Commission and National Advisory Council for the Center for Civic Education. And we could go on and on, that those are just a few of our qualifications of our very distinguished speaker. Would you please welcome, with applause, and if you are at home, please bang your keyboard on your table. Please welcome Zelalem Begale. Thank you. Zelalem.
Wow. Good morning, everyone. Thank you very much for having me here today. I'm excited to be back at TMCC. Born and raised in Nevada, TMCC has always been a staple of this community, so I'm happy to be back here. Thank you, Department Chair Reed, TMCC President, if he's here or if he's listening. I don't really see Jeff, but Jeffrey Alexander, TMCC leadership, faculty, and students. And a special thank you to my friend Adam Garcia, who is here today, who teaches here at TMCC and worked with me years ago to reorganize and modernize the structure of the NSHE police force in order to enhance public safety across NSHE, in part so we can hold events like this. So happy Constitution Day, everyone. What a great space here at an institution of higher learning to talk not only about the Constitution, but the amendments to the Constitution. Without the amendments, I'm not sure that we could all celebrate today, black and white, male and female, Jew and Gentile, to the extent that we can celebrate today. The framers of our Constitution, great though they were people of their era, and they weren't perfect. One way of thinking about the Constitution and the document itself is as a making of amends. I want you to think about that, a making of amends for some of the lapses and the sins of the founders. And that making of amends begins with the Bill of Rights, the first 10 amendments to the Constitution. And so today I want to take my time to tell, I think, a fascinating story about the Constitution and the Bill of Rights that ultimately centers what I believe to be the most important part of the Constitution, the 14th Amendment. Okay? In fact, if we clicked refresh on the Constitution today, I firmly believe that the 14th Amendment would feature as the main event. For me, the 14th Amendment and its Reconstruction counterparts not only represents the second founding of America, as some scholars have described it, it also truly remakes America in its original image, which was poetically recast by Abraham Lincoln in the Gettysburg Address, and which was originally articulated in the Declaration of Independence. We're celebrating the 250th anniversary next year. We hold these truths, we can say this as like a creed, like the Pledge of Allegiance, right? We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, and that among these are life, liberty, and the pursuit of happiness. That's not the Constitution, that's the Declaration of Independence, right? I'll connect the two momentarily. Endowed by their Creator with certain unalienable rights. What does unalienable mean? It means you can't alienate the right. You can't trade it. You can't sell it. You can't get rid of it even if you wanted to. It's unalienable. And life is unalienable, and liberty is unalienable, and the pursuit of happiness is unalienable. You can't give it away. You have it. There are certain things that only you can do for yourself. You know, people can't sleep for you. People can't eat for you. People can't think for you. That's what liberty really meant in the original framing, was the freedom of conscience, the freedom of thought, what we ended up calling the freedom of speech. That liberty of the freedom to think for yourself is endowed by your Creator. It's actually, so it's not really quite yours. It was given to you, and you can't really get rid of it. And in fact, life on this view, this natural rights view, was an unalienable right. So on a certain view of natural rights, you don't have a right to suicide on this view because your life's not quite yours, actually, right? It's unalienable. So you're not at liberty to spurn it, right? So on this view, liberty as a concept, meaning the freedom of conscience and thought, was critical to our founding experiment and was not totally incorporated in the Constitution and the Bill of Rights, and I'll tell you why, and eventually explain how it ended up involved in our experiment through the 14th Amendment. Okay, I'm getting ahead of myself. 70 were invited, 55 attended, only 42 stayed until the end. And no, I'm not describing my 40th birthday party. Okay. I didn't invite that many people to that. I'm, of course, describing the Philadelphia Convention of 1787. 238 years ago, a group of 55 men ranging in age from 26 to 81 convened to revise the broken Articles of Confederation. The weak central government that created left our young country on the brink of collapse. Unable to tax to support the war effort, retaining little power to resolve disputes between states. Paper money was flooding the country, creating extraordinary inflation. Disputes over territory, war pensions, taxation, and trade threatened to tear the country apart. Okay? But in that May of 1787, after shuttering the windows of Independence Hall and swearing secrecy so they could speak freely, that group of men decided to do more than just revise the Articles of Confederation. We, the people, in order to form a more perfect union. With those simple words, they instead launched America's improbable experiment in democracy. In the end, on September 17th, 1787, only 39 of the 42 signed the Constitution. As depicted in Signers Hall in Philadelphia, if you ever go, you'll see three men standing apart, George Mason and Edmund Randolph and Elbridge Gerry. They refused to sign the document. And you can see in the painting they're standing off to the side. The primary reason that they didn't sign the document is because it lacked a Bill of Rights. And why did the Constitution lack a Bill of Rights? Well, as my pastor would say, that's a great question. You're asking some great questions today in this audience. I'll tell you my actual view about this through I think a fascinating story of a pivot by James Madison, who we call the father of the Constitution. James Madison opposed a Bill of Rights in the last week of the Philadelphia Convention, and then opposed the idea of a Bill of Rights, although less emphatically, during the ratification process, but then ultimately championed it in the first Congress. What was he doing? At Philadelphia, James Madison gave a bunch of principled reasons, right, against a Bill of Rights, but the problem was his reasons didn't make sense, they didn't add up, and they contradicted each other. He said, a Bill of Rights is a bad and dangerous idea, it's unnecessary, and plus, we already have one in Article 1, Section 9, Article 1, Section 10. It's what many have called the triple dog bite defense. I don't own a dog, it didn't bite you, plus you kicked it first, right? It's just, they don't make sense analytically. You can believe one of those things, okay, but all three. So what's going on? People aren't really fully conscious of their own motivations. Human beings are complex beings. So this is my reading of the situation. And this is not on the page of the Constitutional Convention notes. This is my sort of interpolation. It's end of September. George Mason, okay, in the last week of the convention, says, hey, we should add a Bill of Rights. And here's my interpretation. Madison sees this, goes, oh gosh, George Mason, he's a pain in the butt, okay? He won't stop talking. He'll go on and on and on. He says it's only going to take 1 or 2 days. It's going to take a week. We're hot, we're tired, we're homesick, we want to go home. Right? Now, and George Mason talk. He was a talker. Now, if Madison had good reasons for actually opposing a Bill of Rights at Philadelphia, then the decision to eventually adopt one later on would be a mistake, right? So he can't be both right in Philadelphia that we shouldn't have a Bill of Rights, and then right 3 or 4 years later when he adopts one. It's like dealing with a witness on the stand, and I've done this before as a prosecutor. Were you lying then, or are you lying now? Because you're telling a different story, right? And I want to tell a story in which James Madison moves in the right direction, explaining his original reasons weren't so good for opposing a Bill of Rights. They weren't so well thought through, and they didn't make sense analytically. But what makes sense for our purposes today is that the Constitution didn't come from just 39 men secretly meeting in Philadelphia. The the Constitution comes from we the people of the United States. The real drama of the Constitution is the ratification process. Okay? When they sign the document on September 17th, 1787, and then send it to the states and say, please ratify this. That year-long process, from basically September of 1787 through September 1788, is where up and down a continent, ordinary people are being invited to debate and ultimately vote on whether they will vote yes or no on the Constitution. That's the drama. And almost the first thing that people say when they get this new document is they say, hey, where are the rights? You forgot the rights. There's no Bill of Rights. What are you doing? What is this thing? And why would they say that? Because this Constitution wasn't the first one America had. Right? These people were familiar with state constitutions. They had their own state constitutions with the Declaration of Rights attached to them. And we had the Virginia Constitution with the Declaration of Rights, which was actually passed in June of 1776 before the Declaration of Independence. We had the Massachusetts Constitution of 1780. We had the New Hampshire Constitution of 1784. Folks were familiar with constitutions and bills of rights. And so they thought, where are the rights? What kind of constitution is this? So James Madison pivots a little bit. He says, look at Article 5 of the Constitution. You can amend it. That's the brilliance of this document. We can amend it. So we can add amendments. Okay? And it's different from the Articles of Confederation because under the Articles of Confederation, one state could veto everything, right? And so the states had so much power. You get one state who doesn't agree, they could veto the whole thing, and that happened a lot. And of course, there's always going to be one, right? And you just know this from life, right? There's always one, okay, who won't tell you where to eat at dinner, or what to buy at the mall, right? There's always one person who disagrees, right? And it was usually North Carolina or Rhode Island. I'm just calling them out because it was. So he sells them on this and says that this is an amendable document. So here's what we can do. You ratify this, and I promise to add a Bill of Rights. If you ratify this, give me some ideas for what you want included in a Bill of Rights. We'll add them after it's ratified. And to do this, James Madison does sort of a second pivot. He has to get elected to Congress now in order to propose a Bill of Rights. And so James Madison runs for Congress, okay, in 1788 on a platform that he will propose a Bill of Rights. He wins the election. He defeats James Monroe. He gets elected to Congress, and to be an honest person, okay, he proposes a Bill of Rights to carry out his promise, to get all these people of good faith who voted against the Constitution, and many did. It was a close vote in Virginia and Pennsylvania, and in New York, the vote was 30 to 27. It was a close vote. Many patriots opposed the Constitution, but they're Americans too. And so in a very sophisticated way, I think James Madison is working to get all Americans to sort of buy into the project, right? To be on Team Constitution, right? As long as it's not a bad idea to add a Bill of Rights, even if it's just a neutral idea, okay? It will give folks buy-in into the project and give them a sense of co-authorship and co-ownership of the project and bring them on board because they are Americans too. Some weren't at the Philadelphia Convention in 1787. At the point of 1788, North Carolina and Rhode Island aren't in the Union yet. And so when George Washington takes his oath of office to be the first president of the United States, there's only 11 states in the Union. And maybe their reasons, North Carolina and Rhode Island's reasons for voting down the Constitution are stupid. Okay, fine. But Madison gives, he provides them political cover. It says, hey, so that you can reverse yourself. Say, okay, we'll now vote for the Constitution now that Madison's pushing a Bill of Rights. Right? He's being magnanimous in victory and providing his opponents cover so they can all get on the same page. You know, they've lost, they're feeling bitter, and James Madison is attempting to bring them on board through a Bill of Rights. Okay, how does he select these rights? Well, he looks to state constitutions. They have a bunch of them. He starts culling through the documents. He gets some proposals from some of the folks at the ratifying conventions, but he also looks to the state constitutions themselves. He's a compiler. He's compiling all of these rights. But there's one amendment, one right, that James Madison wrote himself, actually, that he believes to be the most important. And it's an amendment that would have prohibited states, as well as the federal government, but states in particular, from infringing upon the fundamental rights of conscience, trial by jury, and freedom of the press. Madison believed that states themselves were more threatening to liberty than the federal government. They're closer to the people. The canonical statement of this view is Madison's Federalist 10. And so he proposes this idea and says, here's a bunch of rights that we want to include as amendments. It's a long list. It's proposed in the first House of Representatives. And one of them is this one, limiting state power. Interestingly, it passes the House, but fails in the Senate. And it makes sense that it does, because at that time the Senate was appointed by state legislatures. That was later changed through another amendment. But they were appointed by state legislatures. And so this amendment, which would limit state power, is something the Senate probably wouldn't vote for, and they didn't. And it won't be until after the Civil War that we get a Madison-like amendment limiting state power. No state shall make or enforce any law which shall abridge the privileges or immunities of citizenship, of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. That's the 14th Amendment, ratified in 1868. Not only was this amendment inspired by Madison's previous attempt and his failed proposal, it was inspired by another president's words 5 years earlier. 77 years ago, our fathers brought forth on this continent a new nation, conceived in liberty and dedicated to the proposition that all men are created equal. In the Gettysburg Address of 1863, President Abraham Lincoln reached back over the Constitution to the Declaration of Independence. He reached over the Constitution to the Declaration to reframe and reestablish the American experiment, that we are born equal and that we equally possess the freedom of thought and conscience, what our framers called liberty. It was the 14th Amendment that inserted into the Constitution this equality principle. It wasn't there before. And for our purposes today, I ask not that you view the 14th Amendment through the legalistic framework. We often view it through with different layers of scrutiny, and now I'm getting deep into constitutional law, but strict scrutiny, intermediate scrutiny, rational basis scrutiny, and different classifications, suspect classifications, and non-suspect classifications. Don't view it through that framework today. I ask you to view it at a more basic level, an attempt to bring America together by respecting the dignity and inherent worth of every person. Okay? We're a deeply polarized nation, as you know. But what we have in common is the Constitution. It's Constitution Day, right? What we have in common is the Constitution. What we have in common is the Bill of Rights, the 14th Amendment. What we have in common is more than 230 years together as a people, North and South, blue and red, left and right, liberal and conservative. There are patriots on all sides of the geographic and political spectrum. Just as there were patriots on all sides of the ratification debates. Patrick Henry was famously against the Constitution. He was invited, didn't go to the Constitutional Convention. And when the ratification debates came around to Virginia, Patrick Henry said, "It says we the people, that's a problem. It should say we the states." That's a quote from Patrick Henry. He thought states were fundamental to the project, not people. But Patrick Henry's an American too. And so what did James Madison do? He said, I'll add a 9th and a 10th Amendment. I'll say all rights not specifically enumerated still exist, right? There are rights, if they're not enumerated, they still could exist. Just because they're not enumerated doesn't mean they don't exist. That's the 9th Amendment. And the 10th Amendment, right, protecting states and reserving powers to states that are not delegated to the federal government. So in a very sophisticated way, Madison is recognizing there are patriots everywhere. And I'm asking us to do that today. Because if we're going to start talking to each other and binding the wounds, I think there's no better place to begin than on this common ground of our Constitution, our Bill of Rights, and the 14th Amendment. And importantly, these rights didn't come from judges. They didn't come from elites meeting behind closed doors. They came from the bottom up, organically, from the American people, when for the first time in the history of the world, an entire continent was asked whether we do or we don't, right? Whether we agree to this set of rules or we don't agree to this set of rules. And these are not my ancestors. I'm a first-generation American. My ancestors are in Ethiopia. I'm a child of immigrants, but I identify with this project. I'm allowed to join this project. I was born here. I'm an American citizen. I'm allowed to join this project. So are you. Anyone is allowed to join this project who believes in American ideals and values. You know, we're always one generation away from a barbarous state. And all of this can be washed away unless every generation reconnects with it and learns about it. We're not bound by this Constitution or this experiment. We can amend it again. We can do all sorts of things. We could actually end the project now. But we shouldn't. And we shouldn't do it lightly. And the only way to prevent us from unintentionally running the thing into a ditch, okay, is by studying it with real care. We don't all have to be experts in neurosurgery or plumbing or carpentry or engineering. But we are all citizens or persons living in America, and therefore we are required to engage with the Constitution in order to keep it alive. Thank you. Thanks for having me.
Thank you, Mr. Regala. I would like to open up the forum to questions now. Both, I asked Mr. Regala to leave some time for questions because I thought our audience would have some. I have some, if you don't have any. And our Zoom audience, I wonder if they have any questions for us. Do we have any questions for Mr. Regala now? If not, I'll go ahead and get us started. Mr. Regala, I'd like to ask you about the concept of originalism to get us started. Now, for those of you who don't know, let's not go too deep in the weeds, but just the concept that the original intent of the framers of the Constitution, and that would include the framers of the 14th Amendment.
Correct.
And you can explain this better than I can, but just to get us started here, the idea that the document should be interpreted through the lens of the original intent of the people who created it. Rather than applying it more directly or expanding it to a view from today. What do you think about that particular point of view?
So you described it well. Thank you for the question. I think originalism is what you described it, basically an interpretive method of the Constitution that's basically frozen in amber, right? Like, okay, the Constitution is a frozen document. We cannot, and should not apply it to contemporary problems because the framers couldn't have anticipated them and therefore didn't contemplate them when they wrote the words. I think textualism, which is a form of originalism, makes a lot of sense because, of course, you should begin with the text of anything you're interpreting and read it. Now, are we required to interpret the words written at the time they were written only through the lens through which they were written? I don't know that that's what the framers intended. In fact, I know they included Article 5 in the Constitution, which allows us to amend the Constitution. I think we'd be hard-pressed in the constitutional history to find an example where the framers said, we don't want the amendment process to be used in order to update the document. In fact, no one said that. They didn't limit the amendment process to, we made a clerical error, or we want to remove the 3/5 clause, or what have you. They included an amendment provision in order to allow future generations to update the document for their time. And we've been doing that. We haven't done an amendment in a very, very, very long time, and maybe we should. But yeah, I just don't think originalism, which is taken off sort of in conservative legal circles, especially at the Supreme Court of the United States, sort of viewing the Constitution as a frozen document. I don't know that it has a lot of legitimacy.
Oh, great. Thank you. Do we have any other questions from the audience? I'm not seeing any. I want to ask you, and I'm sorry, I'm not going to ask all the questions. Don't worry, I'm not going to keep you here for an hour. But I would like, the 14th Amendment, I really appreciate you talking about it. One of the provisions in there is about birthright citizenship. And I just wonder, there is an originalist argument against the way it is currently used, isn't there? Or what are your thoughts on that provision? Because the plain text seems to be pretty clear to me.
There are some pretty clear provisions of the Constitution. There are some really opaque provisions of the Constitution, like the Fourth Amendment. We have a lot of jurisprudence surrounding the Fourth Amendment, and probably because it's not very clear. What does unreasonable search and seizure mean? There was not one unified definition and understanding of what that meant at the time, and we've spent a long time interpreting that. What does cruel and unusual punishment mean in the Eighth Amendment? Again, sort of vague terms of art. On the other hand, there are some really clear provisions of the Constitution, and I think one of them is Section 1 of the 14th Amendment, which says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. And, it means what it says. There were some exceptions at the time that folks commonly understood, which were children of diplomats, who were actually, French citizens, or whatever, but happened to be in America and they were born here. They wouldn't be citizens of the United States, but yeah, pretty clear provision, and hadn't really been challenged for a very long time. There was one case, Wong Kim Ark, in the 19th century, which dealt with a child of non-citizens. They were permanent residents in California. But never did anyone view that provision as looking to the parents. That provision's about the child, right? Whether you're born here. Born to who, doesn't matter. That was never, that was not the original intent of John Bingham and the others who wrote the 14th Amendment. It was, if you're born here, you're a citizen. They were mostly looking towards slaves, right, who were born in America, but weren't citizens pursuant to the Dred Scott decision. And so, yeah, I think that was the original intent, was to make citizens out of slaves and to ensure any future person born here is a citizen. And so, yeah, these contestations over birthright citizenship nowadays, are losing in court. I mean, there was one judge, the first judge that saw it was a appointee of President Ronald Reagan in the 1980s, very conservative man, and basically said, well, why are you bringing this case to me? Like, this is the easiest case I've ever had to decide in my 35 years on the bench, right? Birthright citizenship is as clear as day. So that's my view. I share his view.
Thank you very much. One more chance for a question from our audience? If not, that's absolutely fine. Oh, we do have a question.
We have a hand up there.
Sorry, that was my fault there. I didn't see Sydney here. Yes, please, go right ahead.
I have a question regarding the Article 5 of the Constitution. From what I've been seeing the past couple of days, I know I just learned this myself, but you can amend the Constitution, but what doesn't get my brain to wrap around it is so many people don't know that you can amend it, because we have that idea that the Constitution is fixed and that you can't change it at all.
Yeah.
So why do you think it's been created like that? No one really knows that you can make a change because it's in the Constitution, but no one really realizes it.
It's a good question. And so I guess I'll challenge your assumption a teeny bit, the premise, which is that people don't know you can do it. Maybe people don't know you can do it. In fact, there's a lot of people that don't know enough about our government, too many. In fact, the Annenberg Center at the University of Pennsylvania comes out with a Civics Day, Constitution Day survey every year. It just came out today, okay? And the results aren't always great. 60% of U.S. adults can only name one branch of government or something like that. It's not good. But it's improved a little bit over the years. In fact, this year's survey shows a marked improvement. Now 70% of U.S. adults can name two or more branches of government, so that's great. So maybe it's a little bit of people don't know, but I think it might be more of people know you can, but it's so futile. It's going to be so hard to do it. You'd have to convene a constitutional convention. You have to do, add some amendments. How do you do it? Well, you need 2/3 of the House, 2/3 of the Senate, 3/4 of the states. Right? I mean, could you think of anything right now that Americans, or that, the Congress of the United States would agree to, 2/3 of them would agree on something? I mean, it's barely enough. They barely have 51 votes to pass a bill, right? So you need 2/3 of the Senate, 2/3 of the House, 3/4 of the states. And I think people see that process and think, wow, it's probably not worth it. It's never going to pass. Why should we even consider one? That's my view. But I'm sure there's part of it that people just don't know about Article 5. People know about the First Amendment, and they know about maybe the 3 branches of government, perhaps, but that stops at Article 3, and they don't really read past that, right? So I'm sure that's some part of it, but.
Yeah, I would agree. I mean, one of the things is the difficulty of the process, right?
Yeah.
And I think the framers were trying to make it easier. It's obviously easier than the articles, which was
Correct.
unanimous. So they're thinking, oh, this is great, but we do want to make it somewhat difficult.
Right.
So it just can't be willy-nilly done.
Right.
But when you think that the first 10 were passed in 1791,
Yep.
and we have 27 now, that means there's only been 17
That's right,
since
since
1791. And 2 of those cancel each other out. They're prohibition amendments,
That's
right?
right.
So 15 substantive ones. So I wonder, do you think maybe one of the first amendments we might want to consider is making the amendment process more easy?
It's a really interesting idea. Of course, you would need to pass an amendment to have that, right? So it's like a chicken or the egg problem. Yeah, I think that would be an interesting proposal. I'm not sure that this moment we're in America is going to last forever, right? And so I'm a little wary. You know, I'm pretty conservative on that issue of, you know, the Senate is supposed to be the cooling saucer, right? The passions of the Americans will be fought out in the House of Representatives, and then you get to the Senate, and that's where the cool, deliberative body, thoughtful, slow process takes place. And I think I like the balance of that, and I think the amendment process is a version of that. I mean, Congress can pass laws to, you know, to fix a lot of the ills we see in America. We don't need an amendment to change the tax code, right, or to change the structure of the Supreme Court even. That can be, you know, a law passed by Congress. I mean, there are things we can do through congressional legislation that we don't need an amendment for, and so I would be wary of making it easier to pass an amendment, but it's a creative thought.
Yeah, you're right. We don't want. There have been times when change was possible. Like the beginning of the 20th century, 3 amendments were passed.
That's right.
Which is astonishing to think about today. Any other questions? Oh, do we have
Some questions back
here?
here?
Oh, we have one of our Zoom person.
I've got a mic here.
It's not working. No. That's okay. We got you.
So this one's from Zoom. What limits, if any, do you feel should exist on the federal government's power to enforce the 14th Amendment against states?
Enforce the 14th Amendment against states. Well, there's an enforcement clause of the 14th Amendment in Section 5 of the 14th Amendment. It says Congress shall have the power to enforce this amendment by appropriate legislation. Congress has used that power from time to time. The Civil Rights Act of 1875, not one many people know about. There was a Civil Rights Act of 1866 too, and one of 1875, and one of 1955, and one of 1964. We know about the last one, but all of those Civil Rights Acts were passed pursuant to the Section 5 of the 14th Amendment, which allows Congress to pass laws to do that. And I think most of those laws were good. I know the Civil Rights Act of 1964 changed America, changed segregation in America. Brown v. Board was not enough. And so I think placing limits on the state's power to enforce a constitutional amendment shouldn't be very high at all. I think there probably should be none, right? I mean, the court has the power to review laws passed by Congress, and so if Congress oversteps their boundaries and is enforcing the 14th Amendment in an unconstitutional way, then of course courts can step in, strike it down, which they've done many times. In fact, the 15th Amendment has a similar provision, the 15th Amendment, which granted black men the right to vote, has an enforcement clause as well. It says Congress shall have the power to enforce the 15th Amendment with appropriate legislation. They did that and passed the Voting Rights Act of 1965 pursuant to the enforcement clause of the 15th Amendment. And the Supreme Court, decades down the road, actually struck portions of the Voting Rights Act down, saying either Congress used too much authority to pass the Voting Rights Act, or we don't need these provisions of the Voting Rights Act anymore because there's no racial discrimination in voting anymore. That's what they said in the Shelby County versus Holder decision in 2013. So the limits, I guess, would be the courts striking down on constitutional exercises of power, but other than that, I don't see any.
We have another question from our Zoom audience.
Given our divided political environment, do you think there is ever going to be an opportunity for the Equal Rights Amendment to pass, to be ratified?
Oh, good. Well, great question. It almost passed. What's interesting about constitutional amendments is they, it just can take time, right? I mean, James Madison proposed the original Bill of Rights, right, in the first Congress. He was elected in 1788, proposed them in 1789, and they didn't fully pass all 10 of them until 1791. So it took a couple years because it takes time for states to ratify and for, House and Senate to vote on it and all of that. The Equal Rights Amendment is similar. It was originally proposed, I think, in the 1970s, and it's been out there for states to vote on, and states year by year are thinking about it. Recently, I think the President Joe Biden failed to do something procedurally accurate in order to get the Equal Rights Amendment enshrined. I think he claimed victory. I think you can look this up. He said it was passed. It has not passed. But he said it did. I don't know. I think the Equal Rights Amendment is just an extension of the 14th Amendment, Equal Protection Clause. So in a sense, we kind of already have one. And famously, Justice Ruth Bader Ginsburg, when she was a lawyer, used the 14th Amendment, which originally, speaking of originalism, was designed, right, to give equal rights to black Americans, freed blacks who were slaves before the Civil War. She used it to apply it to gender equality. Because the 14th Amendment, on its face, doesn't say race. It just says, no person shall be denied the equal protection of the laws. Women are people too, right? So she read that and said, okay, maybe the 14th Amendment applies to gender inequality as well. The Supreme Court agreed with her. Now it's been used to apply to LGBTQ rights. And so I think the 14th Amendment is a very powerful part of the Constitution that does a lot of the work the Equal Rights Amendment would do if it was passed. So I'm not dodging the question. I don't think in this political environment it would probably pass, but I don't think it needs to because we have the 14th Amendment.
We have a question over here.
All right. What is your opinion on the right to free speech pertaining to digital media and privately owned social media companies? For example, how most media is owned by private companies. They have the right to delete any posts they want and restrict or mitigate or, blacklist anything.
It's a good question. So the First Amendment starts with 5 words: Congress shall make no law. That's how it starts. And it says abridging the freedom of speech, press, right, establishment of religion. Congress shall make no law. That's a limitation on Congress's power. That's what it says. Congress shall make no law abridging the freedom of speech. So when X abridges your freedom of speech, that's not Congress. X doesn't have laws. X might have rules and policies and things, but X isn't Congress. X can limit as much speech as it wants, right? Just because they're a very powerful platform with millions and hundreds of millions of users on it and serving as the sort of modern equivalent of the marketplace of ideas, just because it's really good at what it does, doesn't make it the government, right? It's just not. And so it can limit speech. You don't have the same protections when you're dealing with a private actor as you are when you're dealing with Congress. So I still think you have the freedom of speech, of course, but private actors can limit it, right?
I'm going to exercise my freedom of speech. I will never call Twitter X. We have another question from our Zoom audience.
So given the Supreme Court's recent decision that allows for the administration to conduct immigration raids based on ethnicity, location, or native language, do you feel that this is something that will eventually be passed by the federal government or even Congress as a law?
So we're getting deep in the weeds here. I like it. It's Constitution Day. What a day for that. So what happened in that case, the procedural posture is important. So I will try not to put you to sleep. But the Supreme Court hears basically two kinds of cases. One is the kind we all know about, where people appeal, they file a brief, they argue the case. There's an opinion published. We read it. That's the merits docket, is what we call it. Then there's this other thing, other way they decide cases, now called the shadow docket, I think pejoratively. But it's really an emergency docket where the court can hear cases on an emergency basis without full briefing, without full oral argument. Okay? It was originally designed to address death penalty cases where a prisoner was about to be put to death and they send a desperate appeal to the Supreme Court and say, stop the execution. The court decided to sort of create this emergency docket for that reason in the 1970s around. But since then, it's exploded, right? Now people are using it for all kinds of things. And so this decision about ICE being able to use race to some degree in immigration enforcement was on the emergency docket, okay? And so eventually that case will get fully briefed. It'll go up again to the Supreme Court on a merits docket case, and it'll be fully reviewed and argued, and the court will make a decision. Will it make a different decision? I don't know. I don't predict the future anymore after 2016. I've just stopped. But I think the procedural posture is important, right? So it's not necessarily that they decided that. They just said, we will allow this process to continue pending a real case, a merits case that comes up to us. So that's what they did. Now, of course, in the interim, ICE can do that, right? But it's not a final rubber stamp of the administration's actions. So I hope that made sense.
Anything more? Thank you very much for all your great questions.
Great questions.
One more. Oh, we have a question over here. Oh, thank you. No, we're going to.
Save the most astute for last, huh?
So somebody else is going to be speaking after. Actually, two very quick points of clarification. There are, and I know you know these. There were actually 12 Bill of Rights
That's right.
amendments submitted. One of them, the last one, didn't get approved until 1992.
The 27th Amendment.
Yes, it's the one where Congress, as part of the Bill of Rights, wasn't allowed to vote themselves a raise.
That's right.
And it took until 1992, 212, I think it is, years for that to pass. And even then, it had to be, well, yeah, we can vote Congress a raise, but it won't take effect until after you have a chance to kick us out. And then there's another one which basically would expand the number of representatives up to 50,000 and theoretically increase from there. And that would ultimately, you think it's hard getting 435 Congress people and 100 senators to talk to one another? This would have increased it to like 1,000, 1,500, 2,000, depending. Anyway, and then there is an amendment process that a lot of people don't think about, but it is possible. Every amendment so far that's ever been passed has gone through Congress initially,
That's right.
and then sent to the states for ratification.
That's
There
right.
is another process called and it's part of the Fifth Amendment, whereby the states can get together, and if 3/4 of them say, yeah, sure, we're going to we're going to sign this amendment, they don't have to wait for Congress. You get that many states to do it, who does it? Legislature, committee, et cetera, that's a whole different question, because it's never been done. And then it has to go to Congress for that same two-thirds vote. So, and there actually is, I would be talking about it in my class in, I don't know, a month or so, something like that. There is a process that's in place for that right now amongst a bunch of states to do that. Frankly, they just called a bunch of states together, and whoever wanted to show up, hey, you got an amendment that you think might be decent? Let's talk about it. Let's see where things lie. It's called the Article 5 Convention. If you're that much of a constitutional geek, you could look it up. If we have a moment, philosophical sort of thing on Madison, I don't flat out disagree on the three-dog bite, I think you called it, analogy. But
The
he was
triple dog bite defense. Yeah.
Pardon?
The triple dog bite defense.
There
Yeah.
you go. There you go. I have to remember that one. My understanding, and maybe no more, maybe I misunderstand, I don't know, is in a large sense he was a pragmatist. His initial stance was that he didn't believe that Bill of Rights was necessary, and most of the Federalists at the time didn't think one was necessary because Congress, the federal government, was limited already by what was in the Constitution. If you start delineating rights, then you start saying specifically what the government can't do, which means that they can do anything else. But when it came to, and you're exactly correct on this, when it came to actually getting the Constitution ratified, that he had to change that argument as a matter of practicality, if nothing else, in order to get the Constitution passed, or they'd have been stuck with the Articles of Confederation. And if you, I'd appreciate any thoughts that you had on that distinction.
Great points. I appreciate that. It made me think of a couple things which maybe we'll end on if there aren't any more questions. If you go to the National Archives in Washington, D.C., which every time I go, I stop there. Every time I go to the nation's capital, I make a point to go to the National Archives. It's free. It's open till 5:30. Just go. It's wonderful. And it has the Constitution there. It has a Declaration of Independence there. It has the Bill of Rights there. And the Bill of Rights, it's right in front of you. And there are 12. There are 12. The First Amendment is actually third on the list, right? And so there were 12 that passed the Senate. Ultimately were not ratified by the states. What's really interesting about Madison's original proposal about limiting state power, maybe poetic in history, is that it was actually 14th on the list of amendments that passed the first House of Representatives. Ended up becoming the 14th Amendment, but it was 14th on his list. And I just think that sort of rhyming of history is beautiful and shows a direct connection between James Madison, the 14th Amendment, and of course, the Declaration of Independence, which set forth the equality principle that we so cherish today. Thank you.
Oh, we got a question up front.
Oh, yeah.
Going back to the freedom of speech, you said that private companies can, not necessarily take away your freedom of speech, but, they can limit that because that's their power. You said that Congress can't do that. But Marco Rubio did propose of taking away passports for U.S. citizens who decided to boycott any companies that were working with Israel. That was quietly put down because obviously you cannot do that. But then it was proposed to now revoke visas for people who boycott, companies that are in support of Israel or who have any type of, opinions against Israel. What's your response to that?
To the revocation of visas. So, yeah.
Sorry, just, infringing your right to the freedom of speech and getting
Right.
punished for that
Right.
through government officials.
Sure. It's a really good question. Immigration status is very administrative and procedural, and there are gradations of persons in the United States, starting with citizens at the top, lawful permanent residents, people with temporary status or student visa status, then political asylum, and like non-citizens, right, who don't have proper paperwork. And so within that sort of ladder of immigration status, the government can do a lot, right? I mean, the federal government has broad power over immigration. It's been time and time again asserted by the Supreme Court. It's the one thing the federal government has a lot of power to control is the borders of the country. And so revoking a visa can be very common in general. Now, revoking a visa because of someone's speech, that could be constitutionally problematic. I mean, the First Amendment doesn't talk in terms of citizens, right? It actually talks about the right of speech, the freedom of speech existing even prior to government. It says Congress shall make no law abridging the freedom of speech, like the freedom of speech that existed before we wrote this, like a natural right, like the freedom of conscience or thought that the Declaration was talking about, that James Madison was talking about, the privileges or immunities that we talk about. And so the freedom of speech is something that we inherently have, and the First Amendment was meant to protect that. So I think that could be constitutionally problematic, for sure. As long as there's not another valid basis to revoke the visa, which, right, of course, the federal government might say, we're not revoking it for that reason, for their speech, we're just revoking it because they made some clerical or administrative error, or they overstayed it, or what have you. If there's a non-speech related reason, I'm sure they'll rely upon that, but I would be very surprised to see the government revoke visas only for that reason on paper, at least, because I think that's problematic.
Thank you. Any other questions from our great audience? We have one up here
wow.
in the front.
I heard you mention that you've been to DC, and I just wanted to know, what is since it's so big, there's so much history in DC. What is something that you think, in your opinion, is significant to see? Just because I'm going in next spring, and
great.
I'm like, there's so much to see, and I guess I need a recommendation.
Travel Rex. This is great. I go multiple times a year, and I always go to the National Archives. I always do it. I've not missed it. I think the African American History Museum is great. I love it. The Smithsonian Museum of African American History and Culture, just because it has a lot of cool stuff in there. It has a long arc of history, not just like civil rights movement stuff or matters related to slavery and Jim Crow and things. But they have modern music section. They have an artistic section. They have Chuck Berry's car in there. He used to drive his old '57 Chevy, I think. And they have Outkast's, the rap group's outfits, and they have Tupac's journal, and they have cool history, modern African American history. And so I think that's great. I also recommend going into the Capitol Visitor Center. So it's not really a museum, but if you go into the Capitol, there's an area where non-Congress people or staff can go. It's kind of a museum, but it's the Capitol Visitor Center, and you can walk through it and see some history of Congress, which is really, really fascinating. So those are the 3 places I would recommend.
Thank you very much. Last call for questions. I see we're just about out of time. Thank you very much, everybody. Can we thank our speaker, Mr. Bagala, for sharing his wisdom with us today?
Thank you.
you very much.
Thank you.
Appreciate it, sir.
Thank you.
Thank you for coming and joining us. And I want to thank all of you who attended, both live and on Zoom. And please look us up for history, political science, and law classes. And we have the best paralegal program in the state. So please check that out. Thanks, everybody, and we'll see you next year.